Labor Committee meeting, last one we will have before crossover. Appreciate everybody coming. Senator Robertson, would you open us with a word of prayer, please?
I will. If you'll bow your head with me. Our Heavenly Father, we come before you today, Lord God, as your humble servants. We come before you looking for wisdom, God, and an open heart. As we move through this day, Lord God, let us remember that those we battle with are our brothers and sisters, and at the end of the day, we're required to take care of them. Lord God, I ask all these things in the precious name of your Son, our Lord and Savior, who gave his life for us. Amen.
Thank you. Okay, we've got 3 bills on the agenda today, so committee members should have a revised agenda in your folder. Oh my goodness, there's my Senate. We're going to hear Senate Bill 276, Senate Bill 284, and Senate Bill 243. We had a 4th bill on the agenda, but the sponsor of the bill asked me to hold that and he wasn't ready for a hearing on that. And we do have a hard stop at 10 o'clock. Our first bill is going to be Senate Bill 276, the senator from the 49th, freshman senator, first time presenting a bill before the Senate Insurance and Labor Committee. And I thought I know he's a farmer and an entrepreneur and a great American. I didn't know he was all, an expert on Code Section 33, but apparently he is, because he's in Code Section 49. He's wanting to make a lot of changes to those code sections. I think these laws have been on the books for quite a long time. I don't know what gives him the idea that as a freshman he should come up here and start making these changes. But we'll give him a fair hearing for sure. Senator, would you mind coming to one of these witness mics, or you can go to the podium, whichever makes you. I want you to be comfortable.
Probably ought to be sitting. Thank you, Mr. Chairman. I'm comfortable. After that, welcome. I'm very, very comfortable. This hazing doesn't stop. Thank you, Chairman. Thank you, committee members. So I bring before you today Senate Bill 276, working off LC 520780. And as you mentioned, I'm not an expert in this code, but I brought a couple experts with me today for any technical questions, but I do understand the gist of it. The legislation addresses federal requirements impacting DCH Medicaid third-party liability program. This proposal will ensure Georgia is in compliance with federal law as outlined in the attached letter that I brought with me. I don't know if you guys have a copy of it, but Medicaid is generally the payer of last resort, and so they only get paid for claims for covered items and services if there are no other liable third-party payers for the same items and services. When Medicaid beneficiaries have one or more additional sources of coverage for health care services, third-party liability rules govern the legal obligation of those third parties. Federal law generally requires health care insurers and other third-party legally liable for health care services received by Medicaid beneficiaries to pay for such services. Federal law also requires states to have state laws enhancing the state's ability to identify and obtain payment from third-party resources that are legally responsible to pay those claims. So I think ultimately what this bill may do is save the state money if we hold these insurers, hold their feet to the fire and get them to pay their obligations. So I would appreciate any friendly questions. And I'd appreciate you guys favorable passing this out of committee for me.
Okay, you do have a question.
Yeah.
Senator Kirkpatrick.
Senator Eccles, following up on some that the chairman said, I'm kind of surprised that you're bringing this bill, and I'm wondering how you ended up bringing the bill. Is that a department bill?
I'm just trying, yes, ma'am, it's a department bill, and I'm just trying to make myself as aware of all the issues in the state of Georgia as I possibly can.
Just
That's
follow
a
up.
great question. Thank you, yes.
Yeah, so you know, well, you may not know, I've worked on prior authorization bills ever since I got down here 8 years ago, and this seems like another step in lowering the barriers for patients to get the care that they need. Is that your understanding?
Yes, ma'am. Thank you for bringing that up.
Thank you. Chairman Robertson, or
I want
Yes,
to
we
compliment you on your reading skills. They're impressive.
Thank you,
Are,
Senator.
are we not holding their feet to the fire and requiring them to do that now?
We're not right now, Senator. We're trying to get in line. We're trying to get in line with the
Okay.
rest of the country.
So are you saying other states are doing this?
There's some other states that are doing this.
Okay, and to Chairman Kirkpatrick's concerns, is this going to help patients?
It's absolutely going to help patients.
Have you spoken to those who represents the insurance community, and if
I'm-
so,
I'm
where are
car-
they on this bill?
I'm carrying this bill for DCH, and I'm wearing that brand.
Are you trusting that DCH has done their homework and have reached out to the other parties involved in this to so that we could have a cross the table conversation with those that this legislation is going to
I'm
impact?
trusting they did their due diligence. Yes, sir.
So you're trusting a state agency.
Yes, sir.
God bless you, my brother.
all right, good deal. In my reading of the bill, and you may want to bring your colleagues up for this, but it doesn't appear to me that it's not expanding coverage or providing for any coverage that's not there. It's just eliminating the requirement that pre-authorization is made before so the third-party payers are contractually obligated to cover this, and they're possibly using the pre-authorization as a delay tactic or a trying to stymie, the claim. Is
Slow
that
down the process,
the
from what I
bottom line? I
understand.
mean, ultimately, they have to pay for it anyway. We're not expanding or mandating they cover something that would otherwise be not covered. Is that accurate?
Mr. Chairman,
And-
yes, sir.
and-
My name's Joe Hood. I'm the COO for Department of Community Health. You've summarized it exactly, and the senator previously had mentioned it just lowers the pre-authorization. They can't use that as a defense to say it doesn't meet their requirements for insurability.
I like the bill. Thank you very much. What's the will of the committee? Any further questions? I'm sorry. All right. I got a motion to pass. Senator Hodges. Second, Senator Robertson. Any further discussion? Any amendments? Y'all want to amend the governor's bill?
Change sponsors?
All right, I see no amendments.
Might get a second for that one.
No further discussion. What's the will of the committee? All in favor signify by saying aye. Aye. Opposed, like sign. Passed unanimously, and good luck in the Rules Committee. Tell the Rules Chairman it's an agency bill. He's making a priority of those, so thank you very much. Next, the next two items on the agenda are bills that I'm the primary sponsor. And if you all don't mind, I'm just going to present them from my chair here. The first one is Senate Bill 284, related to the Georgia Uniform Securities Act of 2008. And I do have some people in the audience that may help me with this, but this is a consumer protection bill, in my view. When you have it deals with securities and security investment advisors and fraudulent activity in the securities realm. Current law provides for the Secretary of State he's got a number of tools at his disposal to deal with fraudulent activity in the securities arena. He can remove the investment advisor's license if they are indeed licensed. I'm told that we oftentimes see this activity in cases where the investment person is not even a licensed securities dealer. It's just strictly a fraud, scam type thing. But if they were to be licensed, he could remove their license. There are other things in the code he could do, but the bottom line is his, for penalties on this fraudulent person is basically fines under current law. And this bill would add another tool in the toolbox. If you look on lines 26 through 32, it would allow and there's a lot of due process involved and a whole procedure, but if they're found guilty of fraud, then the Secretary of State could order them to return the invested funds back to the investors, in addition to all the other things he can do, the fines, removing their license. So if there are any funds left, he could require those to be returned to the investors that have been defrauded. And it also gives him subpoena power to try to determine if there are any assets that can be returned to the defrauded investors. So that's my understanding of what the bill does. I'm happy to try to answer any questions, but I'd like to call on some staff from the Secretary of State to maybe add a little more detail to kind of my summary of what I think it does. Yes, ma'am. Good to see you.
Good to see you.
Introduce yourself to
Yes.
the committee and the
Yes.
people watching this online, please.
Yes, my name is Nuala Zaharis. I am the Assistant Commissioner of Securities and the Director of the Securities Division for the state of Georgia, and we are under the Secretary of State's office. Senator Walker, you did a great job explaining this. You should come work with us. So when. So I wanted to thank you, Mr. Chairman, and the members of the committee. My team and I are very grateful that you are taking up this very important measure because it allows us to help our investors who have been harmed by investment fraud. And Senator Robertson, your prayer kind of brought it home to me when you said that taking care of, our people. Well, this bill allows us, all of us, to take care of our Georgians, our Georgia investors. This bill is about being harmed by investment fraud. Investment fraud can be incredibly violating, and anyone can be a victim. There's no victim profile. It's like a death, and the victims that we talk to experience various stages of grief, including denial, anger, and depression. But when we talk to our victims, the question that we always get asked is, how do I get my money back? Well, the Georgia Securities Act, as Senator Walker said, is an administrative act. And currently under that act, we are limited to just ordering civil penalties. We can only order money given back to the Georgia investor by negotiating a settlement, which is a consent order. But these negotiations lead to negotiating fraud out of that consent order, even when we have evidence that fraud has been committed. So this issue kind of creates a misleading public order because the fraud provisions are left out. And so bad faith respondents use these negotiation tactics to state that they did nothing wrong when, in fact, they did commit fraud. But this is a sacrifice we make to get Georgians their money back because it's very important to them that they get their money back. With SB 284, like I said, we can get Georgians their money back. Under this bill, the investor repayment provision is basically limited to the violations related to fraud. This means that the respondents will only be ordered to repay victims if we have found that they have committed fraud. So the money that is returned to the investor is determined basically by what they put in. For example, if an investor contributed $5,000, and believe it or not, to many of our investors, especially some of our seniors, $5,000 is a lot. If we find that they have, committed fraud, we will order them to give that $5,000 back. Basically, this legislation allows us to order that stolen money to go back to the victims' pockets. And we can keep the fraud violations in the consent order and at the same time get the money back to the harmed investors. And I'm here to answer any questions.
Thank you. obviously, I met with them on this bill, and one of my concerns was, due process and what the normal process was, and I have all that information with me. There's several steps in this process, and I also want to point out that this is a fairly kind of rare that this comes up, maybe once or twice a year at the most, that they're seeing cases get all the way to the point where they have to have civil penalties and all of that.
That's true.
Sometimes it's just errors or oversight or poor bookkeeping, and generally those are handled before. I mean, I don't know the right term is, but basically there's an intent or a notice sent to the investment advisor that we're going to potentially have a hearing on this situation, this violation, and they'll then have an opportunity to meet, I think, really privately with the.
They meet privately with us.
So kind of walk through that
Yes.
real quick. I don't
Yes.
want to belabor this. I
Okay.
think the committee's probably good with it, but I just want everybody to understand there is a lot of due process
there's
and a lot of
process.
steps in this, so.
Yes, sir. So usually, as Senator Walker said, we're not going to issue these kinds of things for people who have committed, who may be some registration violations or maybe some books and records violations. This is for individuals who actually have committed fraud. And as the senator said, most of the people who commit fraud do not register, don't want the state to know that they're there. But when we find them, we issue an order. And part of that order is a notice of opportunity for hearing. In other words, they can either elect to come talk to us first, or they can go straight to a hearing. 99.99% of the time, they want to come to the notice of opportunity of a hearing, where we open up a period where we're discussing some kind of settlement. And it is during these that we found recently that they are more open to having the money go back to the investor because they don't want the reputation out there that I committed fraud. So that's what usually happens. So we typically don't end up in a hearing. Very rare do we end up in a hearing.
And then if you have a hearing, they have an attorney
they have an
present if
attorney.
they want to. They have a right, I mean, it's like a trial.
We follow the Administrative Procedures Act, so there's a hearing, and they have their attorney present. We have our attorneys there. There's an we have a hearing officer. We appoint a hearing officer for that.
And that's an outside.
That is an outside person. Yes, a third-party, independent individual,
Okay,
to be fair.
all right. Yes, ma'am, we have a question.
Yeah, my question is currently, if money is collected back from the fraudster, if we want to call them something,
Yeah.
does that money go back to the general fund under current law?
Yes, it does. It goes back.
And
to-
isn't it true that the person who's been defrauded needs that money back a lot more than the
Yes, they
general fund
do.
does?
Yes, they do.
Thank you. Yes, sir.
This is, this usually, in the cases that you're dealing with, are for people who do not have a broker-dealer. The word securities is a broad terminology.
Yes.
From that standpoint. Could be a CD that's not backed or an investment that's not backed. But because if you're dealing with someone who is registered with a broker-dealer, you're going to bring the broker-dealer into play as well as the representative. Am I correct?
That's correct, but the broker-dealer firms and those investment firms, they have very good mechanisms in place, so we very rarely
I was
ever
gonna say,
see
yeah.
anything like this happen here. Yeah.
This would really be for someone who's probably not a registered rep or not
Yes.
securities licensed, and they're doing it really what I call private transactions
They're
type
doing private
situation.
transactions. They are actually under the Securities Act because they're issuing investment
Right,
supposed investment products.
right,
Yeah.
right. I've seen a case like this, just exactly what you're talking about.
Yeah.
What the senator said. So the monies that you're requesting do not go to the injured party; they go into the general fund.
They go into the fund, and we're able to issue $50,000 per violation, capped out at $500,000.
How? And I'm just.
It's just a
Yes.
civil fine.
It's a civil fine.
It's a civil fine. So
Yes.
with this, you are going to request them to return the money to the party that's been
Harmed,
wronged.
right.
And then you're also going to fine them, and that fine
Yes,
is going to
it'd go to the state,
to the general
right.
fund.
Yes,
Okay,
yes.
okey-doke. Very good, thank you.
Thank you, thank you.
Senator Hodges, what number are you, 10?
10, please. Just one quick question. If you find somebody in violation and you order them to return the money to the person who was defrauded, and they don't do it, and you can take them to court and find that they're in violation of the order, and you can fine them.
Yes.
Do you have any mechanism to go after? I mean, if somebody doesn't want to pay, I mean, what mechanism do you have? Can you seize assets? Can you?
So we have to, at that point, go to court, and we would turn this over to the Attorney General's office. They would file a complaint in Superior Court, and that's where we would go.
So you can get an order in Superior Court
Yes, we
proving
can.
that they owe
Yes.
you, and then the
Yes.
court could then allow seizure of assets
Yes.
to pay the fine?
Yes.
Okay, great. Thank you.
Any other questions? Do I have a motion? Motion do pass, I think. Senator Robertson, is that, I don't want to put words in your mouth. No. In a second. Senator Kirkpatrick, any further discussion? Any amendments? All right, all those in favor, please signify by saying aye. Aye. Opposed, like sign.
Thank you.
All right, thank you.
Thank you
Bill
very much,
passes.
everyone. Thank you.
And that was LC 550536. Did I need? Now. All right, the last on the agenda is Senate Bill 243, excuse me, which is LC 394660. It relates to the Back the Blue Fund. And let me just give you all a little refresher and history on Back the Blue. Before our current Lieutenant Governor, when he served in the Senate, this was an idea that he had as a state senator. He got elected to Lieutenant Governor and asked me to work on this and see if I could move forward with his idea on the Back the Blue Fund. As you all know, sheriffs are constitutional officers. They have a lot of wide range of duties in our state, and a lot of it's laid out in the Constitution. The legislature in the last really 5 to 10 years, frankly, has worked hard to try to improve the compensation and do things for our state law enforcement, and in raises, and we've been working on retirement issues, other things to try to help our state law enforcement officers. We have been unable to do anything for the sheriffs, and really what I'm talking about is the sheriff deputies and the jailers, because they don't work for the state. And so we've not been able to do anything as far as compensation. Back the Blue was a unique idea to try to do something for our sheriff deputies and jailers through a voluntary opt-in or voluntary donation, essentially from the citizens of Georgia to the Back the Blue Fund when they register their vehicles. So when they renew the registration for their vehicles, they can voluntarily donate $5 per vehicle to the Back the Blue Fund. And the idea was that these monies would then be, it'd be collected by the Department of Revenue, remitted to the Georgia Sheriff's Association, divvied up with our counties, and then the sheriffs could use the funds. The sheriffs couldn't increase their pay, but they could use the funds for bonuses for their sheriff deputies and jailers. So that was the idea, as a way for Georgia citizens to be able to show appreciation and support for our sheriff deputies and jailers. When the bill got through the House and the Senate, the governor's office contacted me and put me on notice, so to speak, I guess, that there were some legal concerns with the way the bill was written. And I'm no lawyer, so, but I sort of gathered that it was surrounding gratuities clause and then maybe sort of surrounding, I guess, possibly constitutional issues with regard to what you were sort of directing sheriffs to do. And they asked me to, they liked the concept, and the governor wanted to sign the bill into law, but they asked me to commit to working with them in future sessions to make some changes. They didn't spell out what the changes would be, but they said we have some constitutional issues with the bill. If you'll, I guess they assumed I was going to get reelected and all that. But anyway, I committed to working with them as I think anybody on the committee would, and we want to get it right for sure. Quite candidly, I was hoping they would forget it, but they did not. And so here we are with some cleanups to the Back the Blue Fund to try to address the constitutional concerns that the legal counsel for the governor's office has. And that's about all I know to say about it. I do think we have Mr. Terry Morris is in the audience representing and Mike with the Georgia Sheriff's Association. Terry Norris. What did I call him? Morris. Terry Norris. He is a good friend of mine, even though I got his name wrong. Good to see you. Would you come to the podium, Mr. Morris and Norris, and tell us? Speak to the bill, please.
I see the hazing continues. So, thank you, Mr. Chairman, members of the committee. In all my years of being at the General Assembly, this is the first opportunity I've been able to be before your committee or any insurance committee of any sort. So I'm a little out of my space here. But I do want to thank you for talking to us about this bill and certainly about Back to Blue last year. You did a really good job of explaining why, how Back to Blue even occurred. And that was dating back to 2016 when Governor Deal rightly, in September of that year, announced his idea to help state law enforcement with additional salaries. And the General Assembly has had the wisdom to do that a number of times over the years. At about that same time in the following years, the General Assembly tried to figure out ways to help local officers, not just sheriff's officers and deputies and police officers, but chiefs of police. And as you all know, all of those local entities are funded by local county governing authorities and municipal corporations. So there wasn't really a lot of way to do that. I will say this, there's certainly a lot more local officers, sheriff's deputies, jailers, and police officers than there are state officers. And again, there was no nexus or connection that the General Assembly could make to actually help all these people. So it was the Lieutenant Governor and you, sir, that came forward and tried to figure out a little way to help sheriffs. And as you appropriately said, there are many and varied duties that sheriff's offices, unique duties that sheriff's offices perform. They perform those duties because historically General Assemblies and governors have said, Sheriff, you do this. So there's a lot they do in addition to law enforcement. And this was a way to help sheriff's offices help their deputies and their jailers on retention matters. You all know this. County governing authorities fund the Office of Sheriff. However, the Office of Sheriff is not a department of county government, and sheriffs do not work for the county commission. So in many cases, in the aftermath of 2016, many counties did come forward and were able to help deputies more. This was a way to do that. So understand the conversation about needing some change, and I would propose this. If it is the Georgia Sheriff's Association that is the concern of the governor's office, then we'd like to suggest the bill contemplates sending the collected funds from revenue to the Georgia Peace Officer Standards and Training Council. We presently contract, as the chiefs of police do, with the Post Council for our annual training dollars that the General Assembly appropriates. You all appropriate for us. And they use their money to help chiefs, and we help ours use deputies, train deputies and sheriffs. That money, our contracts would post is administratively attached to the Georgia Department of Public Safety, State Patrol. If the Sheriff's Association is one of the issues, us receiving the money, it would be our suggestion that the Department of Revenue pay that money directly to DPS. I believe they would accept that. They have the mechanism to cut those checks to the sheriffs. The second thing might be the current law contemplates equal payments to each of the 59 sheriffs. This bill seems to be a little gray area in this bill. We'd like to make sure that all of that money goes to sheriff's offices and not, be somehow through some discretionary means of a state agency not being divided equally. And then finally, there's a portion in the bill, and I apologize for not having the line numbers. There's portions in the bill that seem to diminish the original intent of Back to Blue, which was to allow sheriffs to give additional incentives, thank you very much, incentive pay to deputies and jailers. And this bill seems to somewhat lessen that language where it's somewhat questionable. And really finally, I said finally before, finally the bill talks about county governing authorities. Let me back up a little bit. The bill contemplates using county appropriated or authorized funds for sheriff's offices that were designated for training. Let that money be used for any incentive pay or any bonus pay, while this money would go to replace that money in the county's budget. That is totally an unworkable provision. There is no way, for a couple of reasons. Some sheriff's offices get no specific appropriation for training. It's just embedded in their budget. So there would be likely no way for county governing authorities to even negotiate that exchange or that replacement of dollars in lieu of using county dollars for training. So those are our concerns. But again, I guess the biggest point would be this. We took on last year without objection the ability to distribute this money to sheriffs, and we would do that still. The Sheriff's Association wasn't gaining a nickel from it, but we certainly don't have that objection to moving it to certainly DPS as opposed to the Post Council. So that's the extent of what I had to say, unless there's some questions.
Any questions? Yes, sir. What?
We good? Thank you, Terry. I appreciate you coming in. Now, the last piece you just talked about said y'all had some concerns. If I look on line 58, it says money distributed from the Back the Blue Fund shall not be used to supplant the salary of the sheriff, nor supplant or replace funding by a county governing authority for the operations of the office of sheriff. So does that alleviate your concerns on the supplantation of county funds with this money?
Yes and no.
Well, I just want to hear the no part.
The no part is, and I'm looking for it in the bill, there's a portion in the bill that says that the training funds that were to be appropriated or authorized by the county that would go to the sheriff's office, those funds would now be held back, and the actual Back to Blue money would go into the county budget. In other words, it looked to us like that the Back to Blue money, really they wanted to, it contemplates wanting to be used for training, and that the training money that was going to be used, paid by the county to the sheriff, would then be used for the Back to Blue.
Well, what I'm reading on line 27,
Uh-huh.
it says there is created the Back the Blue Fund for the purpose of, and what once said providing bonus payments to, was amended to say supporting training and retention of certified peace officers employed under a sheriff in this state.
Okay.
Does that seem to clear up that problem?
If we think retention would allow those funds to be used for incentive pay for the deputies and jailers.
I mean, isn't that what we use incentive pay and bonuses for now, is to retain what we have?
That does change the language, is all I'm saying, yes.
Yeah.
If we can presume that, I think that part is okay.
Yeah.
But there's another part in the bill. If you look at
Is it 53?
53, yes.
Said money distributed from Back the Blue Fund shall only be used, then you go through the strikes, for training of certified peace officers employed by the county sheriffs or any other costs incurred by the sheriff's office related to such training.
Yes.
So you're thinking
But
that.
if you look at 55 through 58, or 9, look at that, see what that says. Any monies otherwise allocated by the county governing authority for training purposes would be used to increase the salaries. See, it contemplates to us that it's saying, you're not going to use the Back to Blue money for the training. I mean, you are going to use it for training. You're not going to use it for the bonuses. You're going to use county money for the bonuses.
It says any money otherwise allocated to such sheriff by the county governing authority for training purposes be used. So you're saying, your interpretation is that any training money that the county would have normally allocated is allocated for retention and bonus and other thing, so that all of your training funds would have to come from Back the Blue?
Yes, that's my reading. And so it looked to us like the bill contemplates using county money for training, but Back to Blue money for bonuses that would go back to the county. So I guess the real final part would be, where does the money go? Does it go to a special account for the sheriff, or does it go to the county governing authority? Which, no disrespect to the county governing authority, but that money would be commingled with other county monies. And I know the supplantation language is in there, and that is good, but that is a very difficult proposition to enforce.
I have a question about the process, because in line 45, it used to say distribute the money in equal portions to the sheriff of each county, but it doesn't say that anymore. So if I live in Cobb County and I give my $5, then it goes to the Georgia Peace Officer Standards and Training Council, right? And then is it divvied up by county from there? And is that equal, or is that pro rata by county?
Under the current law, it's equal. Under this
I think that
law,
was
it's
struck
questionable.
on line 45.
Yes, ma'am. That was another concern. And honestly, no disrespect to post counsel, because we use them, we need them, they help us a lot. But if the bill is, if the language doesn't become more specific on that point, then are we looking at a possible need by post counsel to go through administrative procedures to create rules to decide how it goes? I don't know the answer to that. It was a question we had, though. Thank you, ma'am.
So, Mr. Norris, I think the Department of Revenue said that they had gotten in January. So this just started effective January 1 of 25.
Yes, sir.
And I was told, I don't have anything in writing, but that there was between 40 and 50,000 received in January that would go into this fund. Do you have any updated?
No, sir, I do
figures
not.
on
That's the last we heard as well.
So if we were to extrapolate that, maybe we're talking about possibly $600,000. 50,000 times 12, 600,000 in the fund annually. If a large county, let's not to pick on anybody, but let's say Forsyth County got a fourth of that money, $150,000, and it wasn't divided equally, and they got a fourth of it, that to them would be kind of a rounding error on their budget, whereas if one of my counties got even $50,000, it would be pretty significant for that small county. Could you speak to that a little
Yes,
bit?
yes, sir. I would speak to that. And we have to, I think we have to look at it this way. Each of our counties has a sheriff, has a sheriff's office, has deputy sheriffs, have jailers. And it should not really matter what county you're from, because we all travel all over the state. So our safety is important no matter whether we're in Montgomery County or Forsyth County. So the people from Forsyth County should be just as interested in the other sheriff's offices having the ability to retain officers, trained officers in those counties as well as their own. And your counties, I mean, you've got a district with some counties that do not have a lot. And there's even counties further southwest Georgia that have even less. So this doesn't sound like a lot of money for Forsyth County if we're just dividing it at 159. But it can make a difference to a smaller county that might get $10,000 or $12,000 and be able to use that money, if they can use it directly without any interference from county governing authorities or others, to help offset the cost. And I personally don't like the term bonus myself. I think it's an incentive pay. I think it's retention pay is the way I would refer to it. So that removal of that term to me is not offensive.
Okay. Any other questions from the committee?
Thank you very much.
All right. What's the will of the committee on this? Yes, sir.
Mr. Chairman, I think moving, and I guess a question, would this be a bill that we would engross, because it does deal with revenue? But if not, and I'd lean into the two wise elders on the committee, but I do think that if we move this bill forward, we can make the adjustments that are concerns Mr. Norris. We can attempt to make some now if the chair is willing to entertain a couple of amendments. But I just want to make sure, knowing from where this legislation came and the intent of this legislation, and to push back on any, to be fully transparent, I've not helped develop this legislation, done anything this legislation, but I am a retired sheriff's office employee, and so I just want to make sure that we're doing the best we can do for this, because I know the intent was to make Georgia public safety stronger. So
thank you. This bill, I've never seen a bill out of this committee be engrossed
okay.
on the floor. I don't know where the posture of the committee is. I mean, I don't have a motion or second, but I think if there's clarifying language in an amendment, that would be acceptable. If there's significant shift in the policy part of the bill, I think we'd need to have further conversations.
Chairman, I move to pass at this time.
Okay, I have a motion to pass. Second. All right, now we have opportunity for further discussion or amendments. Yeah, number
Mr.
8.
Chair, I'm not quite sure how to fix this, but I still think it's very unclear how the money's going to be distributed once it's collected, because we did have it in equal portions in the bill, and that's gone now. So it doesn't specify how the money's distributed to the counties. So maybe Senator Kauser or somebody who wears a legal hat can help figure that out. I just uncomfortable with no information about how the money's going to be divvied up.
Okay. We have, it's 9:49. We do have a hard stop at 10, but we do have a few minutes. If we could just pause, I'll give you an opportunity to speak to legal counsel if you want to try to address that issue in a possible proposed amendment. We're going to pause now. Okay, we're going to call the meeting back to order. I think we may have an amendment or two from the committee. Number 9?
Yes, sir.
Yes, sir.
I have two proposed amendments.
Okay. Yes, sir.
The first one is on line 53. It starts out for training, between training and of. I would ask to add in or retention. So that line would read, for training or retention of certified peace officers employed by the county sheriffs,
Okay.
or any other costs incurred by the county sheriff's offices related to such training. My second amendment would be on line 56, where it starts with money from the Back the Blue Fund pursuant to this code section. After section, we would insert for training of certified peace officers, any money otherwise allocated to such sheriff by the county governing authority for training purposes be used to increase salaries of certified peace officers employed by such sheriff, is how that would finish out.
Okay, so let me repeat that.
Yes, sir.
So on line 53, after for training, we would add or retention. So it would read, for training or retention of certified police officers employed by the county sheriff's office.
Must go, yeah, by county sheriffs, yes, sir.
And that gets back into sort of original intent was for pay to, that would allow for pay or bonuses. We don't like the word bonuses, but
Right.
essentially that could be a part of a retention
Incentives.
strategy.
Yes, sir.
And then
Incentives.
on line 56, after
Code
code
sec.
section, it would add for training of certified peace officers, and then the comma would stay.
The comma would follow, yes, sir.
Yeah,
The comma
and
would
then-
follow
and
officers.
So that just adds clarity that money that the county's budgeted for training would then be reallocated for compensation. I think is what that does. I think it just adds clarity to that section. It doesn't really change the intent, I don't think, of that section.
Yes, sir.
So we have those two amendments, and that's in the form of a motion. Do I have a second? Second. Have a second. Any discussion on Senator Robertson's amendment? All in favor of the amendment, raise your hand. Opposed, like sign. The amendment passes unanimously. And Senator Kirkpatrick.
Yes, Mr. Chairman, my amendment relates to the money distribution, and it would start on line 44, which would then read, money from the Blue Fund to the Georgia Peace Officer Standards and Training Council, which shall distribute such money in equal portions to the sheriff of each county in the state on a per-county basis, which is the language that was struck before.
Okay. So you're taking the language that's struck on line 45, which shall distribute such monies in equal portions to the sheriffs of each county in the state on a per-county basis, and you're inserting that after the word council on line 47, so it'll be council, comma, which shall distribute such monies in equal portions to the sheriff of each county in this state on a per-county basis, period.
Correct.
All right, that's in the form of a motion. Do I have a second? Second. All right, any discussion on that amendment? All in favor of that amendment, please signify by raising your hand. Opposed, like sign. All right, that amendment carries. So now we're back to a motion and a second on what now is a committee sub for LC 394660. Any further discussion on the committee sub now? All right, what's the will of the committee? All in favor, raise your hand. Opposed, like sign. The bill passed unanimously. Thank you very much. One more item of business. You'll find in your folder some information on an organization that the state of Georgia is a member of. It's the National Council of Insurance Legislators. We are a dues-paying member. The state of Georgia is. I have started attending these meetings. I think I've been to 3. They are very, very good sources of information. The purpose of the council is to try to adopt model legislation. As you all know, insurance is regulated on a state-by-state basis, and we want to maintain that authority on a state level. We don't want the federal government regulating insurance. So because of that, to improve commerce and competition and make the system work good, it's nice if states have some uniformity throughout the country on insurance laws. It makes it better for the consumer. It saves money for the insurance companies, which they can pass on hopefully in lower rates. But it's a really great educational group. I will tell you, their meetings are in really nice locations, but you rarely leave the hotel to see these nice locations. It's a working group. It's not unlike our committee system here, but legislators from all over the country participate. Oftentimes we have insurance commissioners from all over the country. real good presenters. I encourage you all to consider attending. There's stipends available to help defray the cost of attending. And in November, we have the honor of hosting their November meeting here in Atlanta. So the spring meeting is in Charleston, which is a lovely place to go. Summer meeting's in Chicago, and the fall or winter meeting is in Atlanta. So
Chicago's not a lovely place to go.
in the summertime it is. If you all have any questions about this, so I've got several House members are participating. We need a few more senators to participate. But I just wanted you to be aware of that. I'm happy to answer any questions offline on that if you have any. But any other business to come before the committee? All right. Thank you all for your attendance, and the meeting's adjourned.